You get into the house, you kiss, might make out on the couch for a little bit, then you hold each other's hand and go to the bedroom. Does the sexual activity of the charge start when the bedroom door closes, or does it include the kissing? Is that sexual activity?
Very good point.
Yeah.
Look at how artificial this is. So the kissing and holding hands or touching in a living room prior to going to a bedroom is interpreted, frankly, in my opinion, as prior sexual activity. And may not be relevant.
It quite
now.
often is. You have to assume, as a defense lawyer going in, you have to assume that it will be interpreted that way. Because if you're wrong, and then you get there, you're not going to be able to talk about it.
And that relates to, so that one would think it's all part of the general flowing of the evening, the subject matter of the allegation. So if there's this intimate contact that's truly consensual and ongoing, that would be subject matter of the charge. No, it's parsed out and can be excluded in some insane world.
So the Crown in the McKnight case, on appeal, not at trial, but on appeal, they conceded a couple of things, saying that they now accept that sexual activity other than the specific act alleged to constitute an assault may form part of the subject matter of the charge, right? Because previously they had taken the position that only non-consensual activity was subject matter of the charge. So anything consensual, even if, in the middle of a sexual assault, a person says, but then I had a really nice kissing moment with them, you wouldn't be able to talk about that because that was consensual, right? I mean, I don't even know. It was like, and there's some great quotes from judges saying how you can't parse things out because it gets ridiculous at a certain point. But the Crown had conceded, they gave an example, agreeing that a subject matter of the charge, notwithstanding an allegation of assault, could include something like kissing in the living room and then walking hand in hand to the bedroom where they proceed to where the accused is giving evidence, proceed to consensual sex. So it would be practical and sensible to treat that entire interaction as a single episode of sexual activity. The Court of Appeal in Alberta disagreed with the Crown on that.
Do you get that? Like, this is so subtle. This is a very sort of academic drill down on this, but this is so important as a basis of law in Canada, a fundamental shift in evidence law here, and this will impact other jurisdictions. So the Crown thought it was part of one flow of information as to how the evening progressed, as we call in the business one transaction. The Court of Appeal said, no. What happens in the kitchen or what happens in the living room prior to going to bedroom are all prior sexual acts, and you have to try and bring a motion to see how it's relevant. That means we are sanitizing, we are artificially breaking up what is human interaction. And we are eliminating from it truth. They talk about the truth-seeking process. Give me a break. This eliminates relevant information that leads to the truth-seeking process.